appeal in the matter of Cassini SAS and Arnold Pasture designated activity company and others.
Yes, Mr. Allison.
May it please your lordships, I appear together with Mr. Perkins for the appellant Cassini. Mr. Bayfield, Queen's Counsel, and Mr. Abraham appear for the first and third respondents, who we've called Emerald. As my lords know, this appeal raises a single issue of French insolvency law. The issue is whether the information covenants in a loan agreement were enforceable against Cassini, notwithstanding the fact that it was in the initial period, known as the observation period, of a French insolvency proceeding known as a Sauvegarde proceeding. His Honour Judge Kramer held that the answer to that question was yes. We respectfully suggest that he was wrong to reach that conclusion. Subject to my lords, we propose to start with a short introduction to the appeal before then setting out the structure of our submissions. In doing so, we meet the point that is made at paragraph 3 of Emerald's skeleton, where they seek to characterise our appeal as in essence being grounded solely on a contention that the judge should have preferred our expert on the basis that he had greater expertise. Now, we say to the court that's a mischaracterisation of our case. It's true, of course, that Cassini's expert, Professor Lecour, is one of, if not the most foremost academic authority on domestic French insolvency law. It's also true that Emerald's expert, Dr. Deman, does not, by his own admission, come close to the expertise of Professor Lecour on issues of French insolvency law. Now, we do say that forms an important part of the backdrop to the appeal and the way in which the court assesses the evidence of the experts. But it's not the reason why we contend the appeal should be allowed. What we do say with respect is that the judge was wrong in both his analysis of the principles and the application of the principles of French insolvency law. A large number of those principles, in fact, being common ground by the testimony of the experts, which we'll work through with the court a little later. And in doing so, we'll identify a number of errors that we say the judge made in his analysis. Now, I hope it might be helpful if at the outset we show the court what we say is the paragraph that indicates the key error that then infected, in our respectful submission, the rest of the judgment. And could I invite the court to turn to the core bundle, please, tab 6, where we find the judgment. And it's paragraph 63 of the judgment, which is at page 59, bottom right-hand corner of the bundle. Do my lord see the paragraph beginning, Mr. Allison suggested to Dr.
Yes.
Deman? I recognise that my lords may have read this in preparation, but could I just...
I think you may have is an understatement. We have certainly read it.
Well, my lords, I'm grateful. What we essentially say is that indicates that the judge's approach failed to pay proper regard to the need to take notice of the purpose of the Sauvegarde regime. The short point, as we'll explain by reference to the testimony later, is that the experts were at one on that point. They agreed that the purpose of the Sauvegarde regime plays a key role in the interpretation of the French statutory code. Now, despite that, we respectfully submit that the judge failed to engage with that matter when reaching his conclusion, and failed to engage properly with the fact that his conclusion does not accord with the purpose of the Sauvegarde proceeding. Now, instead of looking at what we say should have been the fundamental plank in the analysis, the judge instead placed considerable weight on a series of French decisions which really aren't on point and certainly aren't reasoned. And we do respectfully suggest that the judge did so with the approach of a common law mind, rather than doing what the French experts agreed and looking at it as he should have done, as the French legal system works.
Did he not do so largely because they've been relied on by you?
Well, my lord, there are a number of cases which I will come to when we turn to the cases. The key case that was relied on by Professor Lecour in support of his evidence, which is a decision of the Court of Appeal of Versailles, We agree the judge was right to grapple with that. We say he was wrong where he came out on it. In relation to the others, we will respectfully suggest that they don't really provide clues one way or the other.
Well, I get the impression that both sides think that, but am I right about that, Mr. Bayfield?
Lord, I think it would be fair to say that one gets limited assistance from the authorities. The way that we see it is that the burden was on Cassini to establish their principle of French law.
Sorry, I didn't mean... Go on.
And that the authorities didn't assist their expert who relied heavily upon them.
Yes. I was really just wanting to drop a hint that, although I see why you want to look at the Versailles judgment, I don't think we're going to be helped by looking in detail at the remainder of the other judgments.
My Lord,
you must take your own course.
No, thank you for that hint. I will certainly take that on board, and what I will immediately do is push the submissions on the authorities to the very back of our oral submissions, and then the court can see to what extent it needs to hear about them at the end. What I was proposing to do in terms of structure, if it pleases the court, is first to highlight a number of key points of the factual and procedural background so as to frame the context in which the issue of French law arises. Hopefully I can take that relatively quickly. Second, to touch briefly on the Court of Appeal's approach when considering an appeal against a finding of foreign law. Again, I think that can be taken relatively quickly because the principles appear to be common ground. Third, to introduce then the French principles of statutory interpretation by reference to the examination of the experts. Fourth, to summarise the key points in Professor Lecour's analysis on the issue of French law to be determined. Fifth, then, to explain by reference to that and by reference to Dr. Demand's evidence why the judge went wrong. And now sixth, and at the back, to the extent the court wishes to hear on it, the other decisions, including the Versailles Court of Appeal decision. So with that, my lords, if I may turn to the first part of our submissions, which is the factual and procedural background to the appeal.
Well, you
and
can
there are
take
three
that very
points.
shortly, as you said.
Well, my lord, I'm grateful. I was going to deal with three things. First, a short introduction to the claim. Second, an introduction to the experts. And third, a quick update on what has happened in France since the decision of His Honour Judge Kramer. The backdrop, and again, at risk of stating what the court already knows only too well, my lords will have seen Cassini is incorporated in France. It's one of the part of a group which is one of the largest event organisers in the world. The key fact for this case is it has borrowed over 570 million euros under a loan agreement, which is governed by English law. The COVID-19 pandemic, in effect, shut down the business of the group overnight, and that led in September of last year to Cassini and other group companies entering into the Sauvegarde proceeding. Now, it's common ground that the legal effects of the Sauvegarde proceeding, as a matter of French insolvency law, fall to be recognised in England pursuant to the Recast Insolvency Regulation, notwithstanding Brexit, because that proceeding was commenced before the end of the transitional period. The Sauvegarde proceedings began, as the court knows, with the observation period, which gives the debtor breathing space to formulate restructuring plans. And when doing so, insolvency office holders called judicial administrators are appointed by the French court to supervise that process. So that's the Sauvegarde proceeding. Then, who are Emerald? Emerald are hedge funds specialising in the sale and purchase of distressed debt. They say they now hold around 55% of the commitments under the loan agreement, and they say they bought those after the Sauvegarde proceeding had commenced. It's common ground the SFA does, on its terms, impose obligations on Cassini, including information obligations. They are clauses 26.7 and 28.25 that we have at tab 11 of the core bundle. Subject to the court, I wasn't going to turn those up unless you think it would be of assistance to look at them now.
Could you briefly outline what the nature of the obligations is, even if you don't take us to?
My lord, of course. There are essentially two different strands to the information obligations. One is the provision of information, so documents, to the lenders. The other is the provision of access to key personnel, so they can speak to key personnel about the financial condition of the group. So it's documents plus access to individuals. My Lord,
When you say access to individuals, does that mean that the individuals are under a contractual obligation to answer the questions? And if so, how does that work?
No, my Lord, the individuals themselves are not, but there's an obligation. The obligation is placed on the company itself to provide that access.
So what does that mean? Giving an email address or something?
I think there's reference to meetings, isn't there?
My Lord, if I can just help, it's 28.25 at page 110 of the bundle. So 28.25a, my Lords will see the obligation is put on the obligors, including Cassini, that each member of the group will permit the agent or the security agent free access at reasonable times to access the books and records, and then the B is meet and discuss matters with management.
I mean, presumably the analysis would be that Emerald says, can I come round at 10 o'clock next week, on Monday next week, and I want to discuss this, this and this. And the contractual obligation of the company spelling out of this would be to make the management available, subject to prior commitments, that would all come under reasonableness, and instruct them to answer the questions frankly.
My Lord, absolutely subject to one clarification, if I may, which is the right isn't given to the lenders, including Emerald. The right is given to the agent or the security agent.
Yeah. That's how it would work. That's how it would work.
Yes.
And if they said, "Okay, we've got to meet these people," but they didn't tell them anything, that would be a breach of the obligation.
A breach of the obligation on the part of the company, yes. Against that backdrop, in March, Emerald issued the Part 8 claim for declaratory relief as to whether the information covenants remained enforceable against Cassini as a matter of French insolvency law, notwithstanding the commencement of the Sauvegarde proceeding. My Lords will have seen that the judge rejected the evidence of Cassini's expert, Professor Lecour, and accepted the evidence of Emerald's expert, Dr. Deman. I was then going to deal with the second aspect of the background, which is an introduction to the experts. Now, we fully recognise that the appeal cannot be determined on the sole basis that Professor Lecour is a more respected authority than Dr. Deman. We fully recognise the court needs to stress test and consider the evidence, but we do say it's important for the court to understand the respective experience of the experts, and in that regard who Professor Lecour is, and to understand his role in French insolvency law and the development of French insolvency law. Now, if I could perhaps make that point good by referring the court to the evidence given by Dr. Deman himself.
This is all in the Stellarton argument, isn't it? That he made various concessions to that effect. Do you need to rub our noses in it?
My Lord, no. If I could perhaps just
right.
with the court's indulgence, remind the court of a few of the key points, which is Professor Lecour has not just written one of the leading textbooks on companies in financial difficulty, which is now in its 11th edition. Dr. Deman accepted that that book is regularly cited by France's highest court when reaching its decisions. He also accepted that Professor Lecour has inspired the judgments of France's highest court, and that he's regularly cited by other professors in their commentary on French insolvency law. And for my Lord's note, the passage is at Supplementary Bundle, tab 9, page 216, page 8, line 5 to page 9, line 13. Dr. Deman also accepted that he had sought himself experts' opinions from Professor Lecour in the past, and that Professor Lecour was one of only 3 names in the market that people would go for expert opinions on issues of French insolvency law. He mentioned only 2 other professors in the same category as that of Professor Lecour. Now, we do say that it's important that in stark contrast to that, Dr. de Man's doctorate is in German law, not French law. My lords will see that at the supplementary bundle, tab 9, page 218, page 14, lines 17 to 25 of the transcript. Dr. de Man also accepted that he hadn't written any textbooks on French insolvency law, save for writing commentaries for the German market. So he's not a published author for the French market on issues of domestic insolvency law. He also accepted that his writings are not cited by France's highest court in the same way of those of Professor Lecour. Now, against that backdrop, we put the respective experience of the 2 experts to Dr. de Man during cross-examination, and he fairly and rightly accepted that Professor Lecour has a big advantage on issues of French domestic insolvency law. In fact, he repeated the words "a big advantage" a second time to emphasise the point. So we do say that to the extent that there is not clear treatment, and I think the parties will be almost at one, that there is very little in the way of authorities and academic writings on the point. To the extent there is not clear treatment to be found anywhere, we say the respective experience of the experts is and should form an important underlying theme when assessing their evidence. Now, we also say that in view of that, it is surprising that the learned judge did not simply prefer the expert evidence of Dr. de Man. And if I may just read, my lords, a passage from paragraph 108E, Roman 4 of the judgment. The judge went further, that's page 76 of the bundle. The judge went further and suggested that Professor Lecour's evidence, and this is towards the end of that passage at 108E4, at page 76, the judge went further and suggested that Professor Lecour's evidence might have been unconsciously skewed by his instructions, which have produced an interesting academic argument, as opposed to an accurate exposition of French law. Now, we do say that's a surprising and serious finding to make against one of, if not the foremost respected authority on French law. And we do say, particularly in circumstances where, as the judge recognised, he found it difficult because Professor Lecour gave evidence via an interpreter not being able to see him, and easier because Dr. de Man gave evidence in English in the courtroom and was able to read the reactions of the judge. We wonder whether something has, so to speak, gone wrong in translation.
Well, that may be so, but the judge says in terms he was very well aware of those difficulties and made allowances for them. We all have forensic experience of very eminent experts, when cross-examined and points put to them, giving unconvincing answers. And that can often be as a result of their being unconsciously skewed. I don't find any of this very surprising. Clearly, Dr. de Man was, in the judge's view, a much better witness. Now, that doesn't mean that he had to win, of course. But I don't see why you think it's so surprising that the judge should prefer one expert over another just because the one he preferred is less eminent than the other.
Well, my lord, if I may answer,
it's all right about the substance, hasn't it?
Answering my lord's question directly in that context, what we do say is that it's particularly surprising in circumstances where, as we saw at the outset, the judge recognised that Dr. de Man's analysis gave rise to anomalies that he couldn't seek.
Well,
to
that's
explain
about
and
the
justify.
substance. That's about the substance. You can win on the substance without having to defend the performance of your expert.
And my lord, that is what we will do in a moment by reference to the passages. But if I may risk making one further introductory point on the assessment of the experts, and we'll see it in due course. What the judge also did within the judgment on a number of occasions is place weight on what he termed as the practical experience of Dr. de Man. The fact that he was a sole practitioner in private practice as a basis for preferring his evidence over that of an academic. Now, we'll look at a couple of those later because a couple are actually important to the substance. But we do respectfully suggest that's the wrong way to come at it. The issue is an issue of French law, and the practical experience of one expert versus the other, we do respectfully suggest is an irrelevant matter to the issue of French law that arises. That's the experts. The final point on background is really just to note what has happened since. The issue won't concern the court, but so the court knows, on the 7th of October, safeguard plans were approved by the French court, and therefore the safeguard proceeding came to an end. And the effect of those plans was to term out the debt of Emerald to be repaid over a period of 10 years. Now, of course, the issue as to whether the information covenants are enforceable after the approval of a safeguard plan was not part of the trial at first instance and doesn't form part of the proceedings today. But I simply draw it to the court's attention so they have the full picture.
And just to be clear, has under the safeguard plan as approved, what are the terms and conditions attached to the repayment of the debt, if any?
My Lord, the judgment simply recites the fact that they have been extended by 10 years in a table. That's what the judgment does.
So the term is extended. What about all the other provisions of the loan agreements? What does it say about those?
My Lord, I don't believe it says anything in particular in relation to those. We'll double check, but I don't think there's anything of relevance in the judgment we need to show you on that.
So they continue unaffected?
No, the evidence from our side, to the extent it arises, is they don't, because it would be inconsistent with the term out for 10 years if someone could now seek to trigger an event of default to accelerate the debt, because there is a clear repayment schedule put in place.
I understand why a provision that would be inconsistent with the extension by implication doesn't continue. But what about other things like provision of information, loan to value ratios and all that sort of thing?
My Lord, the evidence on that from Professor Lacour is it's just the maturities that are relevant now and the rest has gone. That's not something I think that's dealt with in any more detail, but we will double check.
So the plan just completely rewrites the sophisticated loan agreements, part of which we've seen, just puts that in the bin and you just get a straightforward, you must repay the following amounts.
An amortisation schedule as outlined in the judgment, yes.
How does it do it? Does it do by amendment of the existing loan agreements or cancellation? I mean, normally a restructuring plan in this jurisdiction would take the existing agreements and either terminate them and put in place something new or restate them. I'm struggling to understand what the plan actually just says.
And I hope my Lord understands, I'm not wishing to be unhelpful in that regard. We don't have evidence specifically on that because the approval of the plan took place after the decision of the judge at first instance. So that particular point is not addressed in clear terms. I don't want to misspeak on that, so I'll double check if there is anything within the judgment, and then if there is, come back to that later if I may.
But the bottom line is none of this arises.
My Lord, not for today, no. That was all I proposed to say on the background. I was then going to move to the second area of submissions, which is the principles to be applied by this court on appeals against findings of foreign law. Now, the good news is I don't believe there's any real dispute between the parties on the principles. We have the key passages in our skeleton at paragraphs 13 to 19. Yes. I wasn't going to turn the cases up unless the court believed it would assist. I was simply going to highlight 3 points, which, again, I believe are common ground. The first is that the authorities make clear that a finding as to foreign law is of a different character to other findings of fact. That point was rightly recognised by my Lord Justice Arnold when granting permission to appeal. The second is that the authorities identify that the role of the appellate court is to examine the evidence of foreign law which was before the court and to decide for itself whether that evidence justifies the conclusion to which the judge came. And the third is that when considering an appeal, the court should sit as if it were a French court applying French law. Now, that in a sense is an elementary point, but it's one that we say is important. And we say it's important because it's easy for an English lawyer to approach all cases, whether consciously or unconsciously, from a common law perspective and give undue weight, for example, to authorities which are only of peripheral relevance. Now, well, if that's all I was going to say on the English principles, I was then going to move to the French principles. Now, there are 5 points which we would highlight of particular relevance to this appeal because, perhaps unsurprisingly, the approach in France is rather different to the approach in England. The first point is that there is no rule of precedent in French law. For the court's note, Dr. de Man deals with that himself in his first report at paragraph 10E, which is supplementary bundle tab 5, page 97. Now that, as the court may have seen, is illustrated by the fact that the decisions of France's highest court, the Court of Cassation, tend to be 1 or 2 pages long with little or no reasoning. They resemble more from English eyes as orders rather than judgments. The second point is that while French law is a civil system, which is based on written codes, it would be a mistake to assume that everything in French law is expressly within the written code. Now, in his first report, Dr. de Man did seek to present the French system as a simple codified system in which everything had to be expressed. And can I maybe just invite my lords to look at one paragraph to make that point good? It's supplementary bundle tab 5, which is Dr. de Man's first report.
Hang on, you're saying he was wrong. So why are you showing us this passage you think is wrong?
Well, if I can, my lord's quite right, maybe I can save considerable time by saying in cross-examination he acknowledged that that was a considerable oversimplification. And to quote what he said in cross-examination, I can give my lords the reference. He accepted that not all principles of French law are expressly codified in the French Commercial Code. And that supplementary bundle, tab 9, page 222, page 29 of the transcript, line 25, to page 30 of the transcript, line 3. Now that had been the matter of a clear treatment by Professor Lecour in his second report, where he did explain that there were a large number of principles of French law which were not codified. And again, maybe taking my lord's indication, I can give my lords the relevant paragraphs. They are in his second report, Professor Lecour's second report, paragraphs 5, 6 and 11, and that's supplementary bundle, tab 8, page 191 to 193. That was in essence accepted by Dr. de Man during cross-examination. The third point, and an important one, is that general principles of French insolvency law are capable of being inferred from the statutory purpose of the Sauvegarde regime, even when they are not expressly addressed in the statutory code. Now that also became common ground during the trial, but I think if the court indulges me, it's important to see how that point developed with Dr. de Man. Could I invite my lords first to turn up the Consolidated French Authorities bundle? Behind tab 2, at page 6, the bottom right-hand number, the red number.
So you want tab?
My lord, tab 2, page 6, bottom red number. This is where the French code on safeguarding proceedings begins. And it's the very first provision, Article L 620-1, that I'd like to draw my lord's attention to. This is where one finds the statement of the purpose of the safeguard regime. And that statement is made in the second sentence of the first paragraph. My lords will see what it said is this procedure, the safeguarding procedure, is aimed at facilitating the reorganisation of the undertaking in order to permit it to continue its economic activity, maintain jobs and discharge its debts. So the purpose is to preserve the business, save jobs and pay creditors. It became common ground during the cross-examination of Dr. Deman that the objectives are arranged in that order of priority. So first priority is saving the business, second priority is saving jobs, and the third priority, which comes last, is the discharging of the debts. Now, in the context of being asked about the role of the principle of the safeguarding proceeding on French principles that apply, he was asked about a principle that had been referred to by Professor Lecour, the principle being that interest accruing on a loan after the date of the safeguard proceeding is treated in the same way as the principle, even though there is nothing in the safeguard law that tells you this. The candidates being...
I'm sorry to interrupt you,
My lord, of
but I'm
course.
a bit puzzled by the statement you made a moment ago, because what you say in your skeleton argument at the foot of page 125, bridging on to 126, is that what was agreed was that jobs were first, then saving the business, and then the creditors. Whereas you've just told us that the priority is in the sequence set out on the face of the legislation.
My lord, I'm so sorry if we have got it wrong in the skeleton argument. I could just...
Well, you quote the cross-examination where it was the witness's evidence is that first is jobs, and that's then repeated.
Well, my lord, I'm sorry for misspeaking in that regard. That was indeed the evidence of Dr. Deman. The point that I really wished to draw out is that the interest of creditors comes last. My lord, I'm sorry. Yes, it is. By the evidence of Dr. Deman was jobs come first, second is the business, and third is the treatment of creditors. The key point being, for the purpose of our submissions, that creditors come last. Now, the principle that I was wishing to address is that it was common ground that there is nothing in the French statutory code dealing with the treatment of interest that falls due after the commencement of the safeguard proceeding. And there are two choices. Either number one, it could be paid as an expense of the safeguard proceeding, or number two, it could be added to the provable claim, the principal claim. And in those circumstances, Dr. Deman was asked about that, and he accepted that
Sorry, is there a reference you're giving us?
My Lord, absolutely. It's supplemental bundle, page 9, tab 9, page 224.
Yes, thank
My
you.
Lord, supplemental on tab 9, page 224, and the passage, if I could maybe invite my Lords to read it, begins at page 38 of the transcript, the miniscript, line 11, and then goes through to page 40 at line 5.
Yep.
So, my Lord, the reason we draw that to the court's attention is there's a recognition by Dr. Demand that the safeguard law doesn't tell you that interest should follow the principal. But as a matter of French insolvency law, it's treated in the same way. Why is it treated in the same way? It's treated in the same way because it would be contrary to the purpose of the safeguard regime not to do so. So that's why we say the purpose of our third point was general principles of French insolvency law can be inferred from the statutory purpose, even where the point is not expressly codified. The fourth point, if I may invite you to stay with the transcript, I'm so sorry, I'm so sorry, my Lord.
All right.
The fourth point is that it was agreed that the safeguard regime and the purpose of the safeguard regime plays a key role when interpreting the provisions of the commercial code. Now, my Lords have just seen that at the end of the passage we read together, that express recognition by Dr. Demand. The point was made in equally clear terms by Dr. Demand later in his evidence when he was asked about the provision relied on by Professor Lacour, Article L622-13. Could I invite my Lords to turn forward to page 240 of tab 9?
So what's the proposition again? How's it different from the third proposition?
The third proposition is that the court can infer points which are not provided for at all within the safeguard regime.
What's the fourth proposition?
The fourth point is that the court can also interpret the written provisions by reference to the safeguard, purpose of the safeguard regime. So 3 is the inference of unwritten principles. 4th is the utilisation of the purpose as a key aid to construing the written provisions.
Okay. Which passage are you taking us to?
My Lord, of course, page 240. On page 103 of the manuscript, beginning at line 24 and ending on page 104, line 6.
So just a few lines.
My Lord, absolutely.
No, that's fine, no problem.
Maybe to save coming back while we're here, can I just invite my Lords to read and keep in mind lines 17 to 21 on page 103. We'll come back to that point later about how the purpose is relevant when deciding whether ongoing contracts are continued.
Yep.
But the point we make while we're here in our submissions is that Dr. Mann accepted that the purpose of the safeguard regime, to use his words, is the overarching principle that is consistently applied by the courts in order to interpret all provisions of the law. The final point on the principles of interpretation is that one of the techniques for construing French legislation is reasoning a contrario. Now, the court will have seen that dealt with in the judgment. For the court's note, there's a treatment of the principle in a textbook, Malimbo and Ballard, which was relied upon by both parties at tab 16 of the French authorities bundle, where they call it one of the three most frequently used techniques for construing statutes. I wasn't going to turn that up now. What I was going to invite my lords to have a quick look at is what Professor Lecour said about reasoning a contrario in his first report. And that's in the supplementary bundle, tab 6. Page 117. And it's paragraphs 11.2 and 11.3. May I invite my lords just to cast their eyes over those two subparagraphs?
Yep.
So, my lords, they are the 5 principles before we start to look at the detail of the analysis. I was then going to move to the 4th area of our submissions, which does concern the key elements of Professor Lecour's analysis. And could we turn to the provision that is relied on and discussed extensively by Professor Lecour? That's in the French authorities bundle at tab 3, and it's Article 622-13. Now, I don't know whether my lords have had the chance to look at this. I was going to go to Professor Lecour's treatment of this principle in a moment, but I don't know whether the court would wish to have a couple of minutes to refresh their memory on this first.
Well, I haven't actually looked at it here, but it's set out in the reports and the skeleton arguments. Certainly, speaking for myself, I feel I'm fairly familiar with it. You're going to be taking
My Lord, thank you.
anyway.
Maybe just to draw to my Lord's attention, to the extent that we use this version,
Yeah.
it's agreed that the word receiver in this should actually say judicial administrator. And that error occurs throughout the text. Now, this provision applies to contrat en cours, which are translated as current or ongoing contracts. it's common ground between the experts that there is no statutory definition of what is an ongoing contract, but that such a definition has been established in French jurisprudence. And what is common ground is that a contract is classified as ongoing if the counterparty of the debtor has not yet completed the characteristic performance of the contract. So ongoing if the counterparty of the debtor has not yet completed the characteristic performance of the contract. Now, before we see how the loan agreement in this case fits in to Article 622.13, could I invite my lords please to turn up what Professor Lecours says about the statutory provision, and we'll see that in the supplementary bundle at tab 6. In his first report, supplementary bundle, tab 6, page 120. Now, with apologies that it runs out to over a page, but if I could invite my lords please to read subparagraph 7 through to subparagraph 11. Could I first make a translation correction that's agreed between the parties? Because my lords will recall that Professor Lecours' evidence was given in French and then translated. In subparagraph 7, Roman 2, it's agreed between the parties that the French has a very important word which has been missed out of the translation, which is the word not after the word may in the first line. So it should read may not constitute. And if with that introduction I could just invite my lords to read what Professor Lecours says about the operation of Article 622-13.
Yes.
Thank you. So that's his introduction to the provision. Now moving to how that fits in with the loan agreement in the present case. The common ground first. It's common ground between the experts that a loan which was... My lord, say sorry.
Sorry, you asked us to read 7 to 11, I think.
My lord, yes.
Only. Okay, well, you're going to come on to what he says subsequently, I think, probably, aren't you?
My lord, yes, I am. I was going to come to what he said subsequently further on, where he does the detailed analysis in relation to this particular agreement.
Okay. All right.
The common ground was that where a loan agreement was fully drawn before the commencement of a safeguard proceeding, that is not an ongoing contract within the meaning of Article 622(13). Now, it's not an ongoing contract because the characteristic performance of the counterparty, the lender, to advance the money has already been performed. So, in order to determine whether the information covenants in the SFA remained enforceable, the question is whether covenants in non-ongoing contracts remain enforceable after the opening of the safeguard proceeding. Now, it was also common ground that to the extent it was a monetary obligation, that could not be enforced due to the moratorium expressly under Article 622-21 of the French Commercial Code. It was also common ground between the experts that the information covenants were not to be characterised as monetary obligations. Therefore, the question identified to be answered is, as a matter of French law.
So what is a monetary obligation? I appreciate, I can see why these obligations on any view aren't. Is it what equivalent to what we would say it was an obligation to pay a liquidated sum?
More, my lord. It's debt or damages. They also talked about damages.
Yes, I see. What about an obligation that can not only be satisfied by you spending money?
My lord, I think that was not addressed in any terms.
Okay.
Save for one point we'll come to in a moment, where the purpose was said to be relevant to whether contracts should be continued. So the question, we say for the court, and the question answered.
Just where you got it. So just for my reference, 62221, the moratorium. Where's the best translation of that?
Well, of course, it's in the French authorities bundle.
Yep.
Behind tab 2.
Okay, so we're back into the
At
original.
page 20.
Okay.
So what that doesn't do is stop you bringing proceedings for specific performance of a non-monetary obligation.
My lord, the evidence of Professor Lacour was that specific performance was not possible for non-monetary obligations for non-ongoing contracts, but only relevant in the context of ongoing contracts where the judicial administrators had continued the contract for the purpose of...
Well, I understand that's what the whole issue is about in this case, but I just wanted to say, as a matter of language, this does not prevent.
My lord, no, absolutely. And there's no express provision in that regard. That's kind of right. So the issue that was taken by the judge and by the experts in their testimony was, as a matter of French law, are non-monetary obligations under non-ongoing contracts, such as the loan agreement, enforceable in safeguard proceedings? Now, as the court knows, Dr. Deman answered that question by reference to the rule of French contract law. Pacte sunt servanda, contracts must be kept. That's a codified rule at Article 1103 of the French Civil Code. I don't think we need to turn it up, but it's French authorities, tab 1, page 2. Now, Professor Lacour had a very different starting point. The SFA here is, of course, a English law governed contract. He said we're concerned with an issue here of French insolvency law, and his evidence was that the Pacte Saint-Sauvegarde law is the wrong starting point when one is within an insolvency proceeding. Now, it's common ground that there is no express provision in the code dealing with whether non-monetary obligations under non-ongoing contracts are enforceable in a safeguard proceeding. What Professor Lacour said, though, is that you get a very strong steer from Article 622-13. Now, in relation to Article 622-13, as we saw in the text and from his explanation, an ongoing contract cannot be enforced against the debtor without the consent of the judicial administrator. So for an ongoing contract where performance is still falling due from the counterparty, it cannot be enforced unless the judicial administrator wants it to happen. And in that regard, we saw the answer from Dr. Deman in cross-examination a little earlier, that when deciding whether to enforce that contract, the judicial administrator will take into account whether it would further the purpose of the safeguard regime.
Sorry, can I just go back to something you said a moment ago? You said that Professor Lacour said that the Pacte Saint-Sauvegarde principle is not the starting point when you have insolvency proceeding. Well, I understand that it may be modified by an express provision such as 622.13, which is what you just referred to. But what do you mean it's not the starting point? I mean, does that mean that because there's an insolvency French law pays no respect to pre-existing contractual relationships? I don't understand what you mean by starting point.
My Lord, can I, rather than paraphrasing what Professor Lacour said, can I show you where he deals with ongoing contracts and non-ongoing contracts? And that's at tab 6 in his first report. Beginning at page 126. And it's paragraph 15, sub 1 through to sub 6. Could I invite my lords to read that section?
Right, I mean, he doesn't say anything about a starting point at all. What he's talking about is how the insolvency legislation approaches contractual relationships, but he doesn't say you just tear up the contract and start from some other point.
My Lord, if I may, so that's the way he analyses ongoing and non-ongoing, and then in response to Dr. Demand's point about Pacta sunt servanda, I wanted to start with his first report. Could I then show you what he says about that in his second report at tab 8, page 197, where I think this may be more directly relevant to the point that my Lord then asked about. It's paragraphs 31 through to 36.
First line of 32, what's been translated as common law, that's not meaning our sense of common law.
My Lord,
It's
no.
something like the general law.
Indeed.
Yeah.
Yeah, but what he's saying is that section 62213, he says excludes the Pacta sunt servanda rule. What he's not saying is independently of section 62213, just because there's an insolvency, you tear up the contracts.
Well, my Lord, paragraph 34,
Yeah.
he's actually saying that we do exclude the common law of contracts and therefore the rule, and there's as an exception that is reinstated under 62213 if the contract is continued.
Well, you're suggesting that independently, therefore, of 62213, because the time has come for the company's rescue, you tear up the contract Pacta sunt servanda, only if it's restored by 62213. But I'm not sure that's what he's... Does he derive that solely from 62213? Or from somewhere else? I mean, where does it say, because you enter a safeguard proceeding, unless restored, contracts have no effect? Which is what you seem to be saying to me.
Isn't he just saying it's the unstated premise of 62213?
My Lord, he does, absolutely. And then with the analysis that we saw that twins...
But I mean, sorry, that's the... I'm just putting my Lord's point to you in another way. I think I was.
He says that...
Where?
But what he does is he says that they exclude the common law of contracts, and there's an exception, it's restored in one case if the contract is continued. So
But he's only saying that, sorry, I shouldn't take over from my law. He's only saying that in 32, that 62213 does that. He's not saying the whole regime does that, but it's restored in certain circumstances in L62213. Is he?
My Lord, well, 35, the conclusion is that it's therefore understood that the binding force of the contracts is, in the corporate bankruptcy law as it exists through the rule of the continuation of ongoing contracts, rejected.
The very fact that somebody is owed money under a contract, pre-existing debt, you don't tear that up.
No, and what he says in that regard is that is then dealt with the rules of proving the claims, which is dealt with within the Safeguard legislation. So in essence, everything is replaced with the ability to claim a debt.
I saw a little bit of that, and I was going to come back to that when he talks in subparagraph 6 at page 127 in the passage you asked us to read about the erasure of the loan in favour of subsistence of the repayment debt only. Doesn't that presuppose there is a restructuring plan approved? What happens if there's no restructuring plan approved at the end of the safeguard procedure?
Well,
or what happens if the company is effectively restored to health independently of a particular debt obligation. What is he saying, that every debt obligation just simply is erased at the beginning of the safeguard procedure, irrespective of the terms of the plan that might subsequently be approved?
My Lord, no, he's not, because he also talks throughout the report, and we'll see it in cross-examine, about enforceability. So it's simply during the safeguard, one can no longer enforce obligations in relation to contracts, save as otherwise dealt with within the law.
But that's not what he appears to say at sub 6, and this is where he appeared, as I understand it, to go with his evidence in front of the judge. That rather than just talking about suspension of obligations whilst the company puts together a payment plan or a safeguard plan to put to creditors, he talks about erasure of the loan in favour of the subsistence of the repayment debt only. I mean, how are we supposed to read the word erasure? I mean, just to try and give you the example that I have a problem to try and illustrate my point. The company is subject to two loan obligations. Let's assume it's only financing. One of them is actually on rather good terms, and the company can perfectly well meet it. In fact, it's rather good. It's rather good terms and conditions. The other one is really onerous, and that's what's dragged the company down. The company goes into the safeguard process. All it will ever want to do is to restructure the second and onerous one, because actually the first one constitutes good money. The plan that it will ultimately put forward to rescue itself will extend or vary the terms and maturities, the date, whatever the interest rates of the onerous loan.
Well, yeah.
Are you saying that both loan agreements are erased at the start of the safeguard process and replaced simply by an obligation, a debt obligation, and that's it?
Well, within the safeguard, that is indeed what the evidence of Professor Lacour is, because those...
Well, irrespective of whatever plan might subsequently be put forward?
Well, no, I think the terms of the plan will then establish the basis on which life is on foot going forward.
Hence my question to you a little earlier. Did the safeguard plan that has been approved in this case deal with the terms on which the obligations in this under the SFA have been continued, other than as to?
And the answer to that is no, not other than the schedule,
So
which sets out the way in which it has to be paid over 10 years.
So it's a bare loan, absolutely no terms of any sort other than a simple repayment.
Simple repayment schedule over 10 years, indeed.
And that's written, that's set out somewhere.
No, the judgment, sorry, my lord, the judgment doesn't deal with anything apart from the table in which...
And is it common ground that the effect of the plan that has been put in place has extinguished, or at some point, all the other obligations under the loan agreements?
My lord, no, I don't believe that's common ground, and that may be another issue that arises in the future within the context of the safeguard plan as approved. That matter not having been before the courts and determined yet, because of course we were pre-approval of the plan last time round.
And the French court, as far as you're aware, said nothing when approving the plan about when all those obligations ceased to have effect.
My lord, that's my understanding. As I said, people have double-checked behind me, and that is correct.
Prima facie, it's extremely, to a non-insolvency lawyer like myself, it'd be extremely surprising if the result were to get rid of the ancillary terms, except to the extent that they are inconsistent with the repayment schedule. If we're told that's the result of French insolvency law, so be it, but it would be surprising.
That's the English eyes and the English view of it, but as we understand the position, there is simply the obligation to pay the sums on the dates on which they become due under the plan. Now,
who do the amounts have to be paid to?
To the to the agent, I assume.
Oh, so the security agent's status continues.
I don't, again, my lord, without checking the paragraph, I don't know if it actually says anything about that. I think it just has a table of payment dates. That's all it does.
But you need to know who you're paying to and on what terms, I assume.
Yes, and the agent will have made a claim within the proceedings.
But so is that just a straight debt claim then?
Which is rescheduled according to the new payment terms.
Well, you say rescheduled. So what I'm saying is, does the status of the security agent as the recipient capable of giving a good discharge on behalf of the underlying lenders, which I assume are still actually the creditors, does that continue? And if so, how? Or has that just been erased by French insolvency law in some way?
My lord, I can't answer that by reference to the evidence given by Professor Lacour. I don't think there's any evidence on that precise point before the court. So I don't want to misspeak on that. The position of Professor Lacour is that everything is dealt with within the plan, and otherwise the terms of the loan are erased. That's what...
Where does he say that? I've just been looking for this. My lord had it in mind, but I didn't write down. Where is it he uses the word erasure?
127 at the bottom. Page 127.
It's also in the next heading on 128.
Speaking for myself, I would have thought that was ambiguous because he may only have been thinking about the monetary obligations, the actual amounts. But I mean, this issue was not before him.
No, not front and centre, absolutely not. It wasn't the issue to be determined. May I just maybe to answer the question of my Lord Justice Snowden in relation to what happens in the event that the safeguard disappears without a plan, if there's a success and the company comes out as safeguard. That was dealt with in the oral evidence by Professor Lacour. Can I maybe show you what he said about that?
Yep.
That's in the supplementary bundle, tab 11, page 291, where there's questions in relation to caducité. The passage is page 7, line 10, through to page 9, line 10.
Just give us a moment to read it.
Of course.
So where do you want us to read to?
My Lord, I'm so sorry. It's page 9, line 10, and this was just to show the court the evidence on the point that my Lord Justice Snowden asked about on what happens if there is no plan.
I don't really quite understand, I have to say, this evidence, because let's say it's a term loan. Okay, the money is advanced pre-insolvency, but it's not repayable until post-insolvency. That's and usually insolvency will be because you're in financial difficulty because you can predict that when it falls due, you won't be able to pay it. He says obligations. He said for a loan contract, the obligation to pay it back is raised when the funds are remitted are paid. Well, that's not the case with a term loan. I don't really understand this, to be perfectly honest.
Well, the point I was showing, my lord, is that if there is a plan, the reimbursement is by dividends under the plan. That's the first point he makes.
Right, so when you talk in our case about the plan having been approved to extend the maturities of the loan agreement, it's actually not that. It's not that the maturities of the loan agreement have been extended. It's actually what? A dividend schedule of dividend payments in the insolvency, you're saying. And so the mere fact of going into insolvency, of going into the Sauvegarde procedure, in effect puts in place a proof of debt process, no more, no less. And that you ultimately will simply have a dividend schedule on what is in effect, what in English law we would call a proof of debt. It's a dividend schedule.
Can I just show my lord what the court has in the decision approving the Sauvegarde plan, so you can see what the court has done. It's towards the end of this bundle, tab 13, page 397. So just to make the point good, at 396, at the bottom you see on these grounds, so then there's the reasoning of the court thereafter. At the top of 397 there's the adoption of the plan, and then the terms of the discharge of the liabilities will be as follows. And they order reimbursement of 100% of the debts over a period of 10 years as follows. And we're concerned with the term loan B here, and one sees under the heading percentage of reimbursement term loan B the relevant dates on which percentages of the loan need to be repaid.
So it says, with regard to term loan B, spreading of liabilities, principal and interest, from the maturity of the term loan B from 2026 until 2031, in accordance with Article 626(18), paragraph 5 of the Commercial Code. So what is that article?
That's at page 38 of the French authorities. Bottom of page 38 onto the top of page 39. And it's essentially the power of the court to impose payment delays.
To impose payments, sorry, I didn't hear what you said.
Payment delays, my lord.
So payment delays on an existing loan agreement, or impose a dividend schedule in an insolvency. There's a difference.
Yeah. Surely this isn't an insolvency. This is a. If you have a Sauvegarde plan, that is inherently different from winding up the company, and in which case having a dividend plan.
My lord, absolutely, because the business continues and there is a schedule approved by the court for the repayment of the loan rather than the realisation of the assets and then payment of a dividend, pence in the pound on whatever is there by reference to the whole loan, yes.
I mean, you know, the whole clue may be in the word reimbursement.
Yeah.
I just...
Is the word dividend has confused us, I think.
Well,
Maybe not. Maybe I'm confused myself.
no, I mean, I'm... This looks like a rescheduling of an existing loan agreement. It doesn't look like something that says all your loan agreement has been terminated or erased and replaced by a right to a dividend in an insolvency.
My lord, yes, although when dealing with the payments, other articles also use the word dividend. For example, 62621 dealing with the registration of claims, and at page 40 the court establishes the procedure for the paying of dividends provided for in the plan.
But is that part of the safeguard procedure provisions?
My lord, yes, it is. It's within the same part dealing with Chapter 6, Safeguard Plan, dealing with the consequences of the adoption of the plan.
Well, it may be that the word dividend has different implications in this context than it would have in English insolvency.
My lord may be absolutely right, and I can't point one to evidence given by either of the French experts on that particular point.
I mean, at page 398, in the middle of 398, just below the first hole punch, it apparently the plan, if this is what is doing, states, or is this the court stating?
This is the court stating, yes.
Stating that the company will be released from its obligations towards its creditors by the payment into the hands of the administrators with responsibility for the dividend plan, which can only be paid between the creditors whose debt has been definitively admitted in accordance with Article 6621 of the Commercial Code. So that doesn't appear to suggest that the obligations towards the creditors have already been released. It suggests that as and when the company pays money into the hands of the administrators for distribution in accordance with the dividend plan, then the company will be released from its obligations towards its creditors.
My lord, yes, the obligations as set out in the table of when they have to pay the sums, yes.
Yeah, but obviously the critical question I'm trying to understand is whether this is on the footing that the contracts have continued as to other terms and conditions, or whether they have been terminated or erased in some way by the insolvency process having commenced, or something en route.
And when we can see what, in due course, what Professor Lacour said about the words in the Court of Appeal of Versailles decision that deals with a similar point, but I can't help my lord by reference to this.
I'll leave
anymore.
the question there, but it's potentially quite a significant question in terms of what the safeguard plan is and what it hopes to achieve.
My lord,
And indeed, in this case, what it has achieved.
understood. Insofar as Professor Lacour, when we look at the Versailles decision, he essentially says that it's just the payment obligations that are there as approved. But we haven't got the French court. My lord asked me the question, what does the French court say about it earlier? And the French court just says this: it has the schedule, but doesn't have a discussion in any more detail in the way that French judgments do not discuss matters in the same way that English judgments do.
Right, where are we going from here?
Could I come back to where we were on statutory purpose, if I may? And my lord saw the detailed explanation by Professor Lacour as to why he said that if, in relation to ongoing contracts, non-monetary obligations can only be enforced if the judicial administrator continues the contract, it would be, in his view, perverse if for non-ongoing contracts, non-monetary obligations could be enforced. And the reason that he says that is the purpose of the Safeguard proceeding. And the point that he was making when we looked at it is ongoing contracts are capable of producing benefits for the debtor. That is why there is the ability for the judicial administrator to enforce the contract. There is still some performance that can be received from the counterparty if the judicial administrator enforces the contract. And he says that in relation to non-ongoing contracts, there is no such potential benefit to the Safeguard proceeding. All of the performance has already come from the counterparty. And in those circumstances, he says it would be illogical if non-ongoing contracts could be enforced, whereas ongoing contracts cannot be enforced by the counterparty, save where the judicial administrator continues them. And just pausing, we do say it's important to ask the question, how would the enforcement of non-ongoing contracts against the debtor further the statutory purpose of the Safeguard regime? How would the enforcement of non-ongoing contracts help achieve the purpose of saving jobs, saving the undertaking, or benefiting the general body of creditors? We say it wouldn't, and we do say that to find that non-ongoing contracts can be enforced but ongoing ones cannot would give rise to illogical and perverse results, as explained by Professor Lacour. Now that was his key passage of evidence we looked at. I was then going to move to the fifth area of our submissions, which is where we say the judge went wrong in view of that evidence on purpose. And we do say the starting point is to look at a loan agreement which was partially undrawn at the date of the Safeguard. So we have a loan agreement which was an ongoing contract. And it would be an ongoing contract because the lender hasn't completed its characteristic performance. Dr. Deman was asked about this, and he accepted that the undrawn part of the loan could be very small indeed. The example we discussed together was around 1.5% of the loan remained undrawn at the date of the Safeguard. And he said that would be an ongoing contract, not a non-ongoing contract. And if it had been partially undrawn at the date of the Safeguard, it's common ground that the information covenants in that loan agreement would not have been enforceable unless the judicial administrator had sought to enforce the ongoing contract by demanding the last small tranche of the loan. And in those circumstances, the lender would prove its claim alongside the other creditors. Can I just show my lords two passages from Dr. Deman's cross-examination that deal with that point? The first is tab 9 of the supplementary bundle. Page 238. could I invite my lords, please, to read from page 93, line 3, to page 94, line 20.
Yeah.
So, my lords, the key takeaway being the punchline at the end of that exchange. If the judicial administrator decides not to continue the contract, not to ask for the last tranche of the loan, the counterparty cannot enforce any information covenants in the loan agreement after the commencement of the safeguard proceeding. What they can do is file and lodge a claim for damages.
And presumably the outstanding principal of the other.
My lord, of course, absolutely.
And do the other provisions of the contract, as regards interest or anything else, continue?
My lord, we were only asking here in relation to information covenants, and one sees that. The other passage I was going to ask my lords to read is just over the page when we then zero in on information covenants at page 95, line 16 to line 25. Now, it being,
So I'm just being,
my lord, I'm so sorry.
I'm just being slow. In your example, there's 10 million which hasn't been drawn, and the administrator decides not to draw that.
Precisely.
Why is that a termination of the contract?
Well, that, because it's an ongoing contract, because characteristic performance has not been completed.
Yes.
So under 622-13 that we looked at earlier, the ability to continue or otherwise is solely given to the judicial administrator. If
But that's to continue to demand performance.
to ask for the last 10 million, because that's the performance that remains on the counterparty's side.
Yeah.
And then we ask at line 16, if there was a loan instalment of 10 million still undrawn, the contract would be an ongoing contract. And the witness agrees and approves that statement. And then he's asked that if he agrees that if the judicial administrator decides not to enforce the contract, in other words, not to demand...
Yeah, sorry, I was being slow. Yeah.
Would the information covenants be enforceable?
I'm there.
The answer is yes, because this is an ongoing contract from the beginning. And the point that we make is that you do then enter into what Professor LeCour says an illogical and perverse situation, because where the judicial administrator elects not to continue the ongoing loan contract with one instalment due, the lender is then, in essence, in precisely the same position as a lender who has lent everything before the commencement of the safeguard proceeding. Neither lender has anything left to lend. It has all been paid across. Its claim is simply to the repayment of the amounts advanced. And in those circumstances, having regard to the purpose of the safeguard regime, that purpose, as we saw, being a key influence in whether to continue ongoing contracts, why is it that one gets into a situation that the debtor needs to continue to respect information covenants in non-ongoing contracts of loans which are not capable of producing benefits for the debtor in the safeguard proceedings because all the monies have already been advanced, on the one hand, but in relation to an ongoing contract which the judicial administrator decides not to continue to perform, in that case it's common ground the lender cannot enforce the information covenants. Yet that is the effect.
I think Mr. Bayfield has something to...
Yes, well, I hesitate to rise, but the passage that you were taken to from the transcript makes clear that the reason why the lender wouldn't be able to enforce the obligations to provide, why the lender wouldn't be able to require the performance of the information obligations is because on this hypothesis, the ongoing contract has been terminated and you can't enforce obligations in a terminated contract. It's not merely that the contract is not continued. The hypothesis, and one can see from
on the
Dr.
whole,
Demand's evidence,
I prefer these points to be made by way of closing submissions, but
I do
not closing, responding submissions. But now you've felt strongly enough to intervene, you'd better deal with that point, Mr. Ellison.
My Lord, of course. Well, in that regard, we say one needs to come back to the overarching purpose of the safeguard regime, which Dr. Demand suggested was the key matter when interpreting how the safeguard law operates. And we do say that one remains in a very odd situation, that one has covenants which are of no benefit to the debtor, which can be enforced on a non-ongoing contract, but on an ongoing contract, the lender is simply left with its claim in respect of the loan. Now, we do therefore say that the judge went wrong at paragraph 63 when he addressed the purpose. I don't know if my lords recall the point we looked at the outset. It's core tab 6, paragraph 63 at page 59.
Yes, well, we reread that paragraph.
And my lords, we do say that the purpose is key there. And the answer given by Dr. Demand in relation to this point, the point raised by Mr. Bayfield, he says the answer is yes, because this is an ongoing contract from the beginning. He then talks about termination, but our key and fundamental point is that when one is looking at the purpose of the safeguard regime and the need to construe the safeguard regime by reference to the purpose of the law, it would be very odd if one ended up in a situation in which non-ongoing contracts, which were not required for the purpose of the safeguard proceeding, gave rise to a position in which the counterparty could seek to continue to insist on the performance of obligations when, in relation to an ongoing contract where the loan is not elected, the counterparty cannot. Both creditors are in the same position. They've both advanced the entirety of the funds that they need to loan, and yet, on the judge's view of the world and Dr. Demand's view of the world, one creditor can still rely on the information covenants, whilst the other cannot.
How is it contrary to the purpose for the creditor to be able to continue to rely on the information covenants?
Because a non-ongoing contract will not produce any benefits for the safeguard proceeding. The counterparty has already delivered its characteristic performance. And in those circumstances...
Well, I see that point, obviously, but suppose it doesn't do them any harm to do it. If they promise to do it, why shouldn't they?
My Lord, this was my next point. In those circumstances, to place the debtor under a continued obligation, the time and cost of performing contractual obligations which are not in the furtherance of the purpose of the safeguard proceeding.
Are they? Well, my point is, what if they're not contrary to the purpose?
Well, my Lord, we would simply say they are, because one would need to incur time, cost in performing contractual obligations which otherwise don't match with the purpose, which is saving jobs, saving the undertaking, and creditors last. So having to spend money dealing
Why would you have to spend money complying with the obligations?
Well, my Lord, we say it's time and money of the debtor undertaking in circumstances where otherwise there is
Why money? Time, I see.
There's no countervailing benefit
Why
which
money?
accords with...
Suppose I'm the creditor and I ask for a meeting, and you have to have the meeting and you have to give information. How does that cost you any money?
Well, two reasons. One, in terms of seeking assistance from external professionals in relation to complying with the information covenants, because apart from anything else, in addition, what the obligation in the present case is an obligation to provide access to the management, and therefore we say taking them away from the running of the business.
Well, that's not right. You're evading the point. You may have there may be other obligations, but where complying will actually cost money. These ones, so far, you haven't shown me how they do. To take up management time, I appreciate in accounting terms, you can have various accounting formulae for saying how much quotes cost each unit of management time is, but it's not an expenditure. You're not actually going to have to expend resources.
My Lord's quite right. It's the displacement of management resource, but more accurately.
It's an opportunity cost.
Exactly, but that's what you have to say.
And although maybe not necessary in every case, one would expect legal and professional advice in relation to compliance with the obligations.
I mean, isn't that the real point? That in a sense, with these particular obligations, it may be quite hard to find any real disbenefit to the company. There may be a theoretical loss of opportunity, but that may be unreal, depending on actually what is required to comply. But we're looking for a general principle here, and not all ancillary obligations will be capable of being discharged without the actual expenditure of real resources of the company. By all means, look a gift horse in the mouth if that's a bad point, but it looks to me at the moment like a good point.
My Lord, it's a point that we would respectfully adopt. As my Lord says, one is looking for a general principle, and to the extent that there are non-financial obligations in non-ongoing contracts which would cause expenditure on the part of the company to comply, we say that's a strong indication that it's contrary to the purpose of the safeguard regime.
Yeah.
And we do say that, at risk of repeating, Professor Lacour was right in the analysis we saw in the paragraphs in his report to discuss the, he would say, perverse and illogical results that would follow in the event that non-ongoing contracts were capable of enforcement in the way found by the judge within a safeguard proceeding.
You may have answered this question, but can I just check that I've understood it? At what point do you characterise the contract as ongoing or sorry, continuing or not continuing?
At the beginning of the safeguard proceeding, you determine whether the characteristic performance has been given or not.
So even in your example of a loan agreement with 10 million undrawn, if the administrator says, oh, actually, could do with 10 million, it's on good terms, I've got the money to repay it, I think I can go with that, draws it down so that the loan is then fully repaid. Sorry, fully drawn.
Yes.
Sorry. It doesn't turn into a non-continuing contract. In other words, he then has to continue to comply with the other terms and conditions of the loan.
No, my lord, it remains an ongoing contract, and the price of continuing the contract, as outlined in 62213, is the continued performance.
So he would have to, therefore, even though the loan had then been totally drawn and there was nothing more to gain from it, from the company's point of view, because he did draw the last 10 million, he would have to continue to provide information and all the other ancillary bits.
Because he took the benefit, yes. Because he took the benefit.
Well, as I understand it, you say whether he took the benefit or not. And in a way, that's the power of your case on this aspect of the matter, which is you say, well, whether he draws down the last 10 million or he doesn't, the result is the same.
Well, where he doesn't draw down the last 10 million, the ongoing contract is no longer continued and enforced.
Well, is that, that's what I was trying to get at earlier, rather badly. The obligation is there. It's not whether he draws down. The administrator could say, there are no circumstances in which I want the 10 million. And in those circumstances, he would be effectively saying, I don't adopt the contract. But otherwise, I mean, nobody ever forces you to draw down the tranche. But as long as he makes it clear, I don't know which way the burden would go, or doesn't make it clear that he's terminating the contract, or keeping open the option, then he's got to comply with the ancillary obligations. That must be the right approach, mustn't it?
No, the common ground, well, no, the evidence there is in relation to an ongoing contract, unless until the decision is made, there's no enforcement of the other obligations.
Well, I understand that, but perhaps I'm putting it badly, but what decision? Is it a decision to draw down, or is it a decision to keep open the possibility of drawing down?
Well, it's a decision to demand the performance of the continuing contract by supplying the promised performance. That's what the law says.
Yes,
So
but there is no promise perform. In a case of a loan facility, there's no obligation to pay the money at any particular time. The obligation is to pay it if asked for.
And in that regard, what we're told is the right to demand performance of the continuing contract by supplying the promised performance to the contracting party of the debtor. Now, as my lord's quite right, there may be an issue as to whether simply keeping open the ability to draw down is continued performance or not. It may be that under the terms of the loan, there is not the ability to draw down for a further period. It may be fact specific, depending on the underlying loan.
but just so I'm clear, an on-demand facility, sorry, a facility that's capable of being drawn at any time, 10 million outstanding. The receipt administrator says nothing about it, doesn't terminate it, just leaves it sitting there as something that he could have recourse to if needed. Do you say that the information obligations continue or don't?
My Lord, we say that unless and until there has been a request for continued performance, they don't.
All right. Well, suppose he says, I don't know whether I want this 10 million, but I want the final 10 million, but I want the possibility of having it over the next 6 months. That is a request for continuing performance, isn't it?
My Lord, it may well be depending on the terms of the agreement, absolutely. Would it help if we just looked at what the provision says again in relation to what the receiver can or the judicial administrator can or can't do? It says the judicial administrator alone has the right to demand the performance of the continuing contract by supplying the promised performance to the contracting party of the debtor. So in my Lord's example, it depends upon the fact.
Depends on how you I won't use the word characterise, how you analyse the performance, what the performance is. In one sense, the performance obviously is paying money, but I'm not thinking for this purpose, the performance may well be remaining ready and willing to pay money.
My Lord, there of course is that argument in the context of...
But this may not matter too much.
I think the only clue I can give, my Lord, on that, recognising the experts didn't directly address this, is when they were talking about a loan agreement, they talked about the performance as being the remission of the funds.
Yeah, it doesn't really matter because this is all effectively off the back of a thought experiment you're asking us to do, namely look at the position if there was some performance still outstanding and comparing that with the situation where there is no performance still outstanding. And for that, you make your point on that basis, and it doesn't really matter what facts would or wouldn't constitute your thought experiment.
My Lord, that's correct. The point, well, Professor Lecaux's point remains, however one characterises the ultimate point.
Yeah, whether the performance assists in actually drawing down the last 10 million
Indeed.
or in being ready and willing to.
Indeed. So that was the evidence and the judge's conclusion on purpose and the key point which we say he omitted. There are a number of other points within the reasoning of the judge where we respectfully suggest that he went wrong. We do say that he was taking account of matters, in particular peripheral matters, which should not ultimately have impacted on the key question in the case. Now, there are a miscellaneous group of points for the court on this. Some may be a lot quicker than others. The first point is just to mention to the court on the burden of proof. The judge said that the burden of proof was on the defendant. And he said he would start with the evidence of Professor Lecaux as the burden of proving French law was on us. And that's paragraph 43 of his judgment. We accept that today is unlikely to be resolved by burden of proof, but we do note it was the claimant who pleaded the French law in their Part 8 claim and sought to have a determination on the fact that French law did not preclude the continued enforcement of the information covenant. There was no defence in this case. The second point is perhaps more important because it does appear to have coloured the judge's assessment of the experts. And this is the analysis of the controllers, how people can get their hands on documents. This was dealt with at paragraphs 33 to 36 of the judgment. Which is page 50 of the bundle. Sorry, page 49 of the bundle. If I may, I'll come to these paragraphs in a moment when I've introduced the issue so the court can see the backdrop to it. But there are two provisions of French law to look at first in the French authorities bundle. Tab 2, page 11, please. My lords, page 11, article 62110. The word used here is supervisors. The word used by the experts was controllers. There's an ability on the part of the supervising judge to appoint supervisors or controllers in the case. That's the first point. The second point over the page at 62111. This is what the controllers do. They assist the court-appointed administrator, and then in the second sentence, they may examine all the documents forwarded to, instead of receiver, court-appointed administrator. So they get all the documents. That's what the Safeguard law says. Now, this point was relevant at trial because it was said by Professor Lacour and said by Cassini that there were other ways within the French insolvency regime for creditors to obtain financial information if they wish.
As a matter of interest, how on earth do you get people to do this when it says that they're not remunerated?
Maybe more than simply goodwill, maybe a strong interest in a successful conclusion of the proceedings.
I'd rather assume they were in-house people from the creditor, or if the creditor chose themselves to pay accountants or whoever to come in and do it. But, yeah, but is that the sort of thing we're thinking about?
Yeah, I mean, it's going to be...
They're not going to be remunerated out of the funds of the company.
They're not. They'll need to pay any time costs themselves in performing the role, yes.
So you're asking the creditors to potentially put good money after bad?
Potentially, but maybe to protect their claim if they have a big financial interest in the matter, they believe it's appropriate to take on the role.
It's like a creditors' committee,
Oh, Lord, yes.
but with perhaps slightly more
Information.
by the sound of it.
Yeah, and it all starts with the creditors asking him to do it.
Absolutely.
Okay.
Could I now please turn up the evidence of Dr. Deman on this point and how this provision worked? And it's tab 9, page 231, supplementary bundle.
I think it would help me. Sorry, where's all this going to? Are we? This is supposed to show up an error in the judge's reasoning. Is that?
It's my lord, twofold. This was the first thing that the judge dealt with under the heading of expert evidence. and it was something that he dealt with to say that Dr. Deman had practical hands-on experience, and
Sorry, but you're being too long. Is this going to the judge's preference for one expert over another?
my lord, yes, it is. He said it was an indication that Professor Lacour was not as even-handed in his evidence.
Okay.
So, tab 9, page 231, page 67, line 21, through to page 71, line 23. Now, it's a relatively long passage, but I would invite my lords to cast their eyes over it, because we will say actually the evidence given by Dr. Deman was rather vague.
Okay, can we just... Which passage are we supposed to be reading?
Page 67,
Yep,
line 21,
yep.
to page 71, line 23, and they're questions in relation to the two provisions my lords have just read.
Okay, well, shall we read them
Thank
now,
you.
and then you can make your submissions about them. Yes?
My lord, thank you. And then could we see what the judge said about this at paragraph 34? Page 50 of the bundle.
You want us to read the whole of 34?
My lord, if I may, because you'll see there the judge deals with the fact that I suggested that evidence was vague.
Yes. Sorry, do you want us to read the whole of
My lord,
34?
please.
Yep.
My lords, then before looking at paragraph 35 to see how he contrasted it with the evidence of Professor Lacour, could I show my lords Professor Lacour's evidence on the same issue, which is tab 12 of the supplemental bundle. Page 324. tab 12, page 324, page 5 of the mini-script beginning at line 9 to line 7 on page 7. My lord will do me the indulgence of reading that, then we can see what the judge says about the evidence.
The phrase information controller in paragraph 12, where does that come from?
My lord, that's the word that we saw as supervisor in the statute. The person who asked to be appointed to the role.
Yes, no, I understood controller. Information controller is just an odd phrase. But perhaps I've just misremembered. Does it say information controller?
No, it doesn't, but that they're talking about the same thing.
Yeah, okay. Yeah. Yes.
Well, that's what we need to see in the transcript on this issue. As we explain at paragraph 56 of our skeleton, it was always common ground that a controller would be unable to bid for the debtor's assets. That was actually dealt with in Cassini's own evidence several months before the trial. So that point was never an issue. Can we then see what the judge said at paragraph 35 in relation to the evidence of Professor Lecour that we've just read? Because we say that is an unfair treatment of his evidence and doesn't justify the conclusion then drawn at paragraph 36.
What's the cross-reference to Professor Lecour's first report?
My lord, that I'll just get my lord the reference for it.
It seems to be possibly paragraph 16, is that right? 11 to 14. I just need it for my notes.
My lord, yes. It's paragraph 1611 at page 142.
What was the phrase, sorry? What was the reference?
My lord, page 142 of the supplementary bundle, subparagraph 11. Each creditor may request to be appointed as a controller, which grants them access to all the documents provided to the judicial administrator and the creditor's representative.
But hang on. But then it goes on to say it was in cross-examination that he acknowledged the disability flowing from becoming a controller, commenting that the creditor has to take a strategic decision whether to pursue information or preserve its options to acquire assets. And that's not in the passage you showed us, is it?
My lord, no, but because
But
that
it
was
is in the passage that follows. Or were you about to take us to that?
No, what the point I was going to make is the one that we make in paragraph 56 of our skeleton, that it was always common ground that a controller would be unable to bid for the assets. That was made in Cassini's own evidence.
All right, but surely you should have shown us, or perhaps I missed. Isn't it page 7, lines 17 to 24? Is that what you asked us to read? I may have just not read far enough.
My lord, yes, in the cross-examination of Professor LaCour, yes.
Is that what you asked us to read?
Yes, it is.
I'm so sorry. I stopped at line 8. It's my fault. So you're saying that
what we say by reference to the passages my lords have just seen is that it was actually Dr. Deman who had to be pushed on this point to identify in the end that all digital, when it said to start with, you couldn't get financial information by this route. Professor LaCour was always clear on this point, that this was a route to get information. There was never an issue between the parties that a controller could not bid for the business in Sauvegarde, and yet what the judge did was to draw a conclusion from the two passages that we've seen to say, number one, the hands-on experience of Dr. Deman, and number two, the fact that it indicated that Professor LaCour was not as even-handed in his evidence.
Well, you may be right. I'm about to say, hard to think the appeal is to turn on a point of this sort, but the distinction the judge is drawing is between what Professor LaCour said in his report and in what he said in his evidence. You haven't yet shown us the passage in the report, so I can't say whether that's a fair criticism, but you don't answer it by saying it was always common ground between the parties. The question is, did Professor LaCour present the position fairly?
Well, my lord, the answer to that we say is yes, because he gives the right to be appointed a controller in his report. He doesn't deal in his report with the fact you can't bid, but as we explained, that wasn't a revelation because that was always common ground between the parties. Whereas in relation to Dr. Deman, his evidence to start with was you can't get financial information by this route, but he rather changed his evidence over the course of questioning on the point as we've seen. And we therefore say that it was unfair of the judge to use this as a distinguishing point to point in favour of Professor LaCour not being even-handed. My lord, the final point was the French authorities.
Yes.
Now, we do say the judge placed too much reliance on a number of cases which really don't go one way or the other. Now, I clearly don't wish to take the court's time on points which are not going to be central to the analysis.
Well, I say that not as a saying in advance what we have thought, but simply what I had picked up from Mr. Bayfield's own skeleton, which I think he's confirmed that he's not himself relying on those authorities. I don't. I'm only saying that so that you don't pick up a false hint. Have I got that wrong, Mr. Bayfield?
Well, given that Mr. Allison may decide how to proceed
Yes.
On that basis, I just want to clarify our position.
Yes, that would be helpful.
Professor Lecour put the French authorities in play. The French authorities do not help him. If anything, they do help us. And the Court of Appeal of Versailles cases is a case that is helpful to the court in the fact that it's fully reasoned, and the other cases will show the court that if the enforceability principle does exist, then everyone has missed the point to date. The other point on the authorities is they do go to the unreliability of Professor Lecour's evidence, because what you'll see during my submissions is reliance on cases in Cassini's principles, in the first report, in the second report, and then when Professor Lecour gets to become cross-examined, suddenly cases which he'd insisted are relevant, he agrees are irrelevant. So the authorities do feature in our submissions. I wouldn't want Mr. Allison to think.
No, well, I wonder whether I pushed you too far, Mr. I think you better take your own course, Mr. Allison. I think everyone agrees that we need to look at the Versailles cases, whether, given that we're beginning to get to the end of your time, you want to look at the others very briefly after lunch, we'll have to see. But you may think it's sufficient to deal with them in reply if necessary. Anyway, you decide, but I would certainly suggest you go to the Versailles case first.
Let's do that then, please.
Unless that's positively unhelpful, I would.
No. Let's do it. Then maybe I can try and refine comments on the other cases.
Yes.
So I'm very brief on them. The Versailles case is in the French authorities at tab 11. It's the only French case of any length in the bundle, but actually the vast majority of the document deals with submissions and appearances. The reasoning of the court doesn't begin until page 83, where one sees the heading discussion. And there are two key passages to show the court that were relied on by Professor Lecour. The first is at page 89. And if my lords could turn to the 6th paragraph on the page beginning current contracts within the meaning, that's where the passage begins. And the passage goes down to the sentence, the paragraph, ultimately as long as the plan is executed. Did my lord see that?
Mm-hmm.
Can I please invite you to read that section?
Yep.
One more passage and then we can see the evidence of Professor Lecour on this case and why he says it's relevant. The court also deal with the position after the approval of a plan, and that's page 90 in general in the Sauvegarde proceedings, page 90, 4 paragraphs up from the bottom beginning, but has been said. Just that paragraph.
be something going wrong with the translation, isn't there? The formal and substantive conditions are not enforceable against the debtor in the safeguard proceedings, nor against the court having to adopt the safeguard plan. That doesn't make very good sense.
My lord, it doesn't. Essentially, when we see the evidence,
Do we have the French?
Professor, we don't have this one. No, I'm sorry.
Okay.
Professor Lecourt,
Yeah. Okay.
evidence is the next place to go, which is tab 10 of the supplemental bundle. Page 278 is the first short passage. And it's the answer given between lines 5 and 15. I could invite my lords to read that. Page 83, lines 5 to 15.
The question for the Versailles Court was what? It was whether to approve the plan, and if so, on what terms, wasn't it?
Yes, absolutely.
Yes. So they're not focusing on the status of contracts during the observation period. They're focusing on the question of whether the plan can be approved in accordance with its terms.
My lord, yes, and what happens to the loan during the execution of the plan? That's what it's focused on.
During the, when you say the execution of the plan, you mean after the
After
plan's been
approval.
approved and
My lord, yes.
right.
Yes. Well, myself, I've read this passage.
And my lords, I'm with an apology in advance. There's a rather longer passage when Professor Lecourt was taken back to the case behind tab 11 on day 3.
Wait, give us
Page
the reference.
313 of the bundle. Beginning on page 93 at line 1, going to page 97 at line 11,
Okay.
where he discusses the decision.
Would you like us to read that?
My lord, please.
Yes.
So as my lords know,
Sorry,
the
am I
judge...
going too fast? My lord isn't quite finished.
No.
No, he's reading more carefully than I
I'm
did.
so sorry.
Okay, thank you.
Yes.
So the evidence of Professor Lacour is that the paragraph that we looked at in particular, the second paragraph, that the formal and substantive conditions are no longer enforceable against the debtor in the safeguard proceedings, includes all terms of the loan and not just terms in relation to maturity. That's the evidence of Professor Lacour, and he says otherwise the creditors get their right to prove their claim in accordance with the safeguard regime. And that's why he relies on that passage to say that it is not simply narrowly addressed at repayment terms, but it goes wide enough to include all conditions of the contract. Now, we say the judge was wrong to reject that evidence and in effect to find that formal and substantive had a meaning that linked it back only to the repayment time.
I mean, insofar as that might be interpreted as referring to the observation period, it's obiter, as we would understand.
My lord, of course, sorry. Yes.
And it's only dealing with payment obligations.
Well,
I mean, what's the issue that the court was grappling with?
the issue in the case is the payment deadlines. Agreed. Also agreed there's no doctrine of precedent, and therefore there's a question as to how broad the words are.
Is there anything in the argument that's rehearsed in all the pages we didn't look at that touches on?
My lord, not that we found that could give a clue in relation to whether this should be read down or not. My lord will have seen from the judgment, and maybe I can just, noting the time, just show my lords what the judge said.
Yep.
It's page 64 of the core bundle, tab 6.
Which paragraph?
Paragraph 79.
Well, 79, I mean starting at 79.
My lord, absolutely. And what the judge found from 79 onwards was that the words formal and substantive should be given a limited meaning in the context of that case, and didn't support the view of Professor Lacour that they, in essence, applied to all conditions of the contract.
Yeah? What's your submission?
The submission is that Professor Lacour's testimony, which my lords have seen, is clear. He gives an explanation as to why formal and substantive should be read to have the wide meaning of all conditions. He says there's no reason to distinguish between one type of condition and another within a contract. And he says elsewhere in the evidence that the purpose of the safeguard is important when construing where one ends up in relation to non-going contracts. And he therefore says that this decision supports his view in relation to the terms of non-ongoing contracts no longer being enforceable against the debtor in safeguard proceedings. In other words, he says he doesn't read this down as dealing only with the payment terms. Now, the judge differed on that point. My lords have seen Professor Lacour's evidence. I may need to show you doctor demands quickly after lunch, but our key point will be that the judge, one, didn't need to get into resolving this particular issue because the purpose arguments we've already outlined should have given the answer. There's no doctrine of precedent, and each case is argued and determined on its own facts. But to the extent that this case does enter the ring, we say Professor LaCour was right to place reliance on it as giving a clear clue that terms are no longer enforceable following the opening of a safeguard proceeding.
Yes. Now, well, as you say, it's we should break now. There's nothing wrong in the party opening the appeal taking rather longer than the party responding, because you've got to show us material which we can take more shortly afterwards. But you can't go on long after lunch. How long do you expect to be?
I think in view of my Lord's indication, with permission, I will finish off the evidence on this case and then only deal with other authorities to the extent that they're expressly relied on by Mr. Bayfield in his submissions.
That probably makes sense. That ought to leave you plenty of time, Mr. Bayfield.
My Lord, I certainly hope it will leave me enough time. We did discuss an equal division of time. I understand my Lord's point that sometimes it takes longer to open an appeal. I'll go as quickly as I can, but I've got quite a lot to cover.
Yes. Well, bear that in mind. Mr. Allison, I think we will be pretty troubled if you go on after 2:15. You will get points by no, you won't get any points. You will get the gratitude of the court if you're rather shorter than that.
I hear, my Lord, and I will spend a short adjournment reducing anything we need to say.
Right. 2 o'clock.
Sounds good.